Good morning, I'm Father X, and today we'll continue our journey through the world of child custody appellate law. Let's make this more real to help you prepare for your custody battle. We'll dive into a real custody case to reveal how the Court of Appeals makes decisions. You can use this insight to see if your family court judge is making decisions correctly. In my custody battle, reading a lot of case law was a major part of my strategy, and why I ended up with primary custody of our son. Some of this is pure gold. Let's get to it. If we go to Google Scholar and select the New York Court of Appeals, which is the highest court in New York, we get the search page for that court's decisions in New York. New York decisions only apply to New York cases. If your case is outside of New York, you can use this case study as an example of how to find and interpret cases in your state when you do research. If we enter a search for the best interests of the child, 257 cases pop up, and the first few are from 1982 and 1996. The first one is Esbach versus Esbach. I want to review it because there are good legal concepts here you can learn. The first page says it's Donald Esbach versus Rita Esbach, a 1982 decision by the Court of Appeals of New York, the highest court in New York. I'll just read portions of the case because it's too long for this video, but read this case entirely to get you started on case law. It's only 3 pages long. Let's do this. The opening sentence tells us, "The question to be resolved on this appeal is whether custody of the youngest child of the parties should be changed, along with that of her 2 older sisters, from her mother to her father. Donald was granted a divorce in May 1979. Custody of the 3 daughters of the marriage was granted to their mother pursuant to an oral stipulation of the parties. The stipulation provided visitation rights for the children's father. And a stipulation means this was an agreement by both parents. So we now see the 2 parents initially agreed to the mother having primary custody." Then the court says, "Events over the course of the next year indicated a progressive deterioration in the mother's relationship with her daughters. On several occasions, the 2 older girls, Karen and Ellen, ran away from the mother's home, either to their father's residence or to friends' homes. Concerned that the children were being raised in an unhealthy atmosphere, which was affecting their emotional and psychological development, the father commenced this action, seeking a modification of the judgment of divorce to the extent of awarding him custody of his 3 daughters." So the case is just telling us about this family situation. No fancy legal language yet. This highest court then says, "The trial court found that the mother's unreasonable demands and restrictions were jeopardizing the older daughter's emotional and intellectual development, and that there was a total breakdown of communication between the older children and their mother. Furthermore, the court found that a strong preference to live with a father, expressed by these children who were aged 16 and 14 at the time of the hearing, should be given consideration. Although Laura, who was 10 at the time of the hearing, had not expressed a similarly strong preference to live with her father rather than her mother, the court recognized her strong desire to remain with her sisters. The court found that her best interests would be served by continuing her close relationship with her sisters, and that a change of custody to her father was necessary under those circumstances." So, this time the lower court gave custody of all 3 daughters to the father. This highest court of appeals then says, "On appeal, the appellate division agreed that the antagonism of the older children toward the mother and their strong preference to live with the father required a change in custody for Karen and Ellen, the 2 older daughters. That court, however, modified the judgment and ordered that Laura's custody remain with the mother because there was nothing to suggest that the mother has been anything but a fit parent toward her. And the Court of Appeal says, on this appeal, the father seeks custody of Laura, the youngest daughter. The mother has not sought an appeal from that part of the order which affirms the judgment awarding custody of Karen and Ellen to the father, the 2 older daughters. The question on this appeal is thus limited to which parent should have custody of Laura, the youngest daughter. We agree with the trial court that Laura's best interests require a change in her custody from her mother to her father. Before I continue analyzing the court's decision, please like, subscribe, and share. Also, if you find this information helpful, please support this channel. Donate on my YouTube channel's About page using PayPal or Venmo. So, what's valuable to us is the logic the court applies in its reason for deciding custody. Listen to this section carefully because it gets very wordy, and then I'll talk you through it. Remember, in May 1979, the parents initially agreed the mother would have primary custody, and the lower court just signed off on that agreement. There was no trial or analysis of the best interest factors to determine what was actually best for the children. And then the daughters started running away from the mother when she got primary custody. The Court of Appeals tells us, where the parties have entered into an agreement as to which parent should have custody, we have stated that priority, not as an absolute, but as a weighty factor, should, in the absence of extraordinary circumstances, be accorded to that agreement. But as this court noted in the Friederwitzer case, no agreement of the parties can bind the court to a disposition, other than that which a weighing of all the factors involved shows to be in the child's best interests. Thus, an agreement between the parties is but one factor to be weighed by the court in deciding whether a change of custody is warranted. The weight to be given the existence of a prior agreement depends on whether the prior disposition resulted from a full hearing by a trial court or was merely incorporated in the court's judgment pursuant to an uncontested stipulation. This is particularly true where the rules of the court require that the decree specify that, as to custody and visitation, no such agreement or stipulation is binding. Since the court was not bound by the existence of the prior agreement, it has the discretion to order custody changed when the totality of circumstances warrants its doing so in the best interests of the child. Think about that, guys. It's a lot to unpack. The Court of Appeals is telling us the only binding child custody arrangement in the legal system is one where the weighting of all the best interest factors shows what's in the child's best interests. They tell us that a custody arrangement can only be declared to be in the best interest of the child if it's one that resulted from a full hearing by a trial court. And that trial court's decision had to be based on the totality of the circumstances and analysis of all the best interest factors. In this case, they're saying the initial agreement of the two parents isn't binding because they didn't go through an analysis of the best interest factors. That makes some sense because the higher court is trying to avoid situations where, as just one of many possible examples, one parent is unfit to be the primary parent, but they're the bully and the other parent just gives up. And you and I both know that either a mother or a father can be the unfit bully who wrestles custody away from the other parent. What is the Court of Appeals really telling us in plain English? They're saying that any decision about child custody that isn't based on intelligent analysis about the totality of the circumstances and all the best interest factors, any decision like that isn't worth much and isn't binding. Why does the higher court say that? Because they want to make sure child custody decisions are based on intelligent analysis of all the best interest factors and the total circumstance. Can you think of other instances where parenting arrangements are made without a full fact-finding and analysis of all the best interest factors? A great example is temporary custody orders made by a judge before any fact-finding is done about the actual best interests of your child. Think about your first day in family court where, for 30 minutes, everyone uses a bunch of cute marketing slogans without real analysis. Then the judge just gives temporary primary custody to the mother. Maybe it's based solely on the fact that she's unemployed, for example. That judge didn't have a full trial and didn't analyze all of the best interest factors or the totality of the circumstances. It's just a quick decision to keep the court docket moving. How do you think the Court of Appeals would interpret that temporary order of primary custody? They would see it as meaningless because it's not based on thorough analysis. I'm sure many of you know the feeling of how, after the mother gets temporary primary custody, the mother, the lawyers, and the judge all pressure you to quit because the mother is going to get default custody. When you get that pressure, recognize that it's probably based on garbage analysis, just like the Court of Appeals warned us about. Because I'm sure your judge didn't have a full trial to determine your child's actual best interests during a brief 30-minute appearance. Since you know the facts, you should view these temporary orders as garbage analysis if they don't reflect the actual best interests of your child. Don't give in to the fear and pressure of the court system. The Court of Appeals is on your side if you're the truly better parent. And the Court of Appeals is the judge's boss. In this case, the Court of Appeals says some of the best interest factors to be considered are the quality of the home environment, the parental guidance provided for the child, the financial status and ability of each parent to provide for the child, the ability of each parent to provide for the child's emotional and intellectual development, the individual needs of each child, as well as the desires of each child, depending on their age and maturity and whether any influence has been exerted on the child. And the Court of Appeals tells us the weighting of these various factors requires an evaluation of the testimony, character, and sincerity of all the parties involved. The existence or absence of any one factor cannot be determinative, since the court is to consider the totality of the circumstances. The Court of Appeals requires us to have intelligent and thorough analysis. One factor cannot determine the outcome of custody because we must consider the total circumstances. Again, when you see any court orders lacking thorough analysis of the circumstance, those court orders directly contradict the Court of Appeals' instructions to the lower courts. Throughout my docuseries, I stress the importance of presenting a complete case in your trial based on all the best interest factors with intelligent analysis. Because if you do, then you'll be in sync with the Court of Appeals. And then it's you and the Court of Appeals versus the half-baked opinion of the lower court family judge. In episode 7D, I revealed the fake laws that many family court judges use. We just saw what the Court of Appeals shows us as the real way to decide custody in Esbach versus Esbach. Let's see if these fake laws are consistent with how the Court of Appeals told us to decide child custody. Fake Law 1. Before a fact-finding trial, it's okay for the judge to issue temporary orders where they ignore the total facts of the case and all the best interest factors. No. It makes no sense that a judge must rule based on all the best interest factors in a final custody order, but they can ignore these best interest factors in a temporary order. That's dumb. Fake Law 2. Whoever goes to court first should get primary custody to start the proceedings. No. The higher court tells us to make decisions based on the best interests of the child. Fake Law 3. A child needs his mother, so the mother should have primary custody. No. The higher court tells us to make decisions based on the best interests of the child, and not on what is potentially the second best interests of the child. Fake Law 4. To be cautious, we should rule in favor of the mother until we sort things out. Ruling on the side of caution is like saying, I don't have any idea what the facts are, and I'm just guessing. When a judge prevents a child from seeing their dad based on guesswork and pretends it's caution, and the dad is actually innocent of whatever allegation is made, the judge is doing real damage to that father-child relationship by keeping them apart. So this alleged caution is creating actual damage on the other end. Fake Law 5. During the marriage, if the parents split responsibilities and the mother was the primary childcare provider, that must mean that after a divorce, she must be the primary custodial parent. No, the higher court tells us we must account for all the factors, not just the one factor that justifies giving the mother custody. When you see the judge making temporary custody decisions based on these fake laws, you must verbally object and say something like, "I object to the court's temporary decision because, as the Court of Appeals stated in Esbach versus Esbach in 1982, the court must weigh all the factors involved to show the child's best interests, and this court hasn't done the necessary analysis to determine the mother should have primary custody, even temporarily." Tailor that speech to fit your circumstances and state laws. You must object on the record. You can't just complain about it afterwards. The more case law you read, the better prepared you are for any fake law the judge tries to use. That's how you start to handcuff the judge and make them abide by the actual law. Many dads tell me they only get 3 hours of trial time, which is only 75 to 90 minutes per parent in a fact-finding trial. With 10 to 15 best interest factors, that's only 6 or 7 minutes to prove each factor is in your favor, including witnesses. That's obviously not enough time for a thorough analysis of the total circumstances, especially if there are years of history. Judges limiting trial to only 3 hours raises a big red flag for me, suggesting the judge wants to limit testimony to avoid getting all the facts into the trial record. For a judge biased against fathers, the worst case scenario is a long trial with lots of testimony and evidence favoring the father for primary custody. So it's in the best interests of that judge to limit trial time to 3 hours and minimize the amount of evidence in favor of the father or against the mother. And if a judge claims they just don't have more than 3 hours to spare for any trial, then if they don't have the time to learn the actual facts of the case, they should just be issuing 50-50 custody to the parents unless there are extraordinary circumstances. Ask the judge for all the time you need to thoroughly present your case so that later the appellate court can see all these facts on the record during an appeal. You can say something like, "Your Honor, based on written law and appellate court precedents, which require a complete evaluation of all the best interest factors, and based on my preliminary outline of the facts and evidence of this case, I estimate my testimony and witnesses will take about 10 hours, or however long you need to tell the full story." Don't accept the judge's uninformed opinion that 3 hours is enough to decide your child's future. Be ready to make verbal arguments in court to justify why you need 10 hours to present your case. If the judge denies your request, you probably need to file a motion with the court requesting more time for trial, justifying that request with details. The judge must respond in writing, making it part of the record. Later, if you appeal the final custody order, you can then share with this Court of Appeals, highlighting that the judge refused to grant enough time to present the totality of the circumstances. I can't guarantee this will work, but it's an option to pursue. Remember, our strategy is that when deciding our children's future, we don't follow the lead of incompetent, lazy, biased, or uninformed judges. Instead, we take the lead by promoting intelligent conversation about our children, and any legitimate court of appeals would agree with us in doing that. These might be the darkest days of your life. They were for me. I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. If you like, subscribe, and share, it'll help get this message out to more fathers. Please support this channel so I can make more videos. You can donate via my YouTube channel's About page using PayPal or Venmo.